Martin Elia Lomuro, the Minister of Cabinet Affairs, as well as the former Minister of Animal Resources and Fisheries in the government of South Sudan, recently faced money laundering charges in Kenya. Where does the case stand at this point? Join us as we discuss this and more only on Beyond the Headlines. Our guest on the program is Mr. Anuol Deng Kuoreng, a barrister who took up the case of Minister Lomuro against the Kenya Asset Recovery Agency that was brought before the High Court of Kenya. Welcome to the program.
Thank you. Thank you, Eunice Malas. Thank you so much for having me here. It's a delight to share with you. So you're highly welcome.
On June 4th of this year, the Kenya Asset Recovery Agency, abbreviated as ARA, obtained an order from the High Court of Kenya to prevent Minister Martin Elia Lomuro from gaining access to his bank accounts at the Cooperative Bank of Kenya. The agency accused Minister Lomuro of participating in money laundering. Now, has your client been laundering money from South Sudan to Kenya? In addition, what led your client to open the bank accounts in Kenya?
To answer your question, I'm practicing in South Sudan, not really in Kenya, but my client was accused in Kenya by Kenyan Asset Recovery Agency on the ground that he had laundered money. Obviously, the answer to your question whether my client has laundered money in Kenya, the answer is no, he has not. And why he opened his account in Kenya is because he has a family there and his children are going to school in Kenya. So for the purpose of easing transaction with school fees and so on and so forth, and to support the family, he had to open a bank account. And that is the reason. So the Asset Recovery Agency brought a case that was so fictitious against our client on the ground that there was suspicious transaction in his account. But on perusing through the files and providing all details, evidence, there was no evidence established that our client was actually laundering money in Kenya. And that is why courts made the decision in his favor that there was no case in which he was found to be laundering money.
Now, how many bank accounts does your client have in Kenya? Not only within the Cooperative Bank of Kenya. And are the accounts in shillings or in dollars or in both forms of currency? And what is the total amount of money that was frozen in those accounts?
Well, my client only had an account in US dollars, which had 130,000 US dollars. And this money came obviously from South Sudan. The account that my client also had is a Kenyan shillings account to help for the purpose of local transaction, because you cannot transact in US dollars in Kenya, you have to transact in local currency. But because his money comes from South Sudan, sometimes you can lose money in the exchange rate in two ways. One is that if you send your money, you pay the bank transfer fee, and then plus the conversion from dollars to local currency. So it was advisable for him, I think through his banker at the time at the Cooperative Bank, for him to open a US dollar account and also Kenyan shillings account. So this is just to transfer his money to Kenya, and then he can withdraw his money from there and then put it into a local currency. So these accounts were receiving money from South Sudan. And obviously what you might want to know is that where is the source of money? And the source of his money was coming from his investment. He had a property that was rented by the African Union. And he also had a property that is being rented by an Eurasian company that is operating along the River Nile. They are operating a hotel called Houses Hotel. So those properties is giving him money, and was this money that he was transferring to support his family.
Yes, you mentioned that in the account that contains the US dollars, it is 130,000 US dollars. And what about the shillings account that contains the Kenyan currency? How much did he have in that account?
Now, you see, this is the paradox of the case, because they were saying that he was transferring money from US dollars to a Kenyan shillings account, but which was not true. So what he has there is just his US dollar account plus his Kenyan shillings account. So without going into details about how much he had in the account, which is not really relevant, because what was relevant is whether he had committed a crime or not.
I think our viewers might consider it relevant to know the amount.
The amount that is there is exactly what I've told you, was 130,000, which was converted into Kenyan shillings and became 13 million Kenyan shillings. So 130,000 US dollars, which was 13 million Kenyan shillings. And this was the money that they quoted in their affidavits that they filed in the court, saying that there is a suspicious transaction because this money was converted into local currency.
You mentioned that he is renting property to the African Union. What form of property is that? Is it a housing unit?
Yes, these are houses, and then the land that is on the riverside.
How many houses are those?
Well, I don't know all of my clients' properties, but one thing that I do know, which was clear in the bank statements, because we took all the bank statements from South Sudan that shows the money that was transferred to Kenya. And it confirmed that African Union was one of the payees that pays into his bank account because of the rent agreement that he had with the African Union. Then also, another thing that we saw was the houses that had a rent agreement with him that also pays into his bank account. So when we were going through the documentation, the bank statements, we saw that he had those rented properties. But obviously, he has other land somewhere which I don't have details of.
How much was he getting monthly, or how much is he getting monthly from the African Union and the foreigner?
According to what we know, he was getting more than 200,000 a year from the African Union contract, and he was getting also more than 100,000 from the houses contract.
Now, as the barrister who brought the case on behalf of your client, Minister Lomuro, in front of the High Court of Kenya, what were the key points of argument that you presented which indicated Minister Lomuro was innocent of the accusations leveled against him and that he should be granted access to his bank accounts?
Okay, for clarity purposes to our viewers, let me clarify that we did not actually bring the case against the Asset Recovery Agency. The Asset Recovery Agency brought a case against our client, and we were responding. So our client was the respondent to the case that was filed. Now, the case that was filed against our client was centered on one important thing, which is money laundering. And the accusation was that our client had been involved in suspicious transactions that warrant the Asset Recovery Agency under Section 3, Section 4, and Section 7 of the Assets of the Proceeds of Crime and Anti-Money Laundering Act 2009, which is the Kenyan law. Under that law, it says that if you know intentional or you had an intention to commit such kind of criminal acts of laundering money, then it is punishable under the Kenyan law. So under that law, our client under section 82 of that same law got what they call a preservation order, which was to deny him access to his accounts. And this preservation order made it clear that he's not going to touch such accounts until the case is disposed of. When of it in June 2021, our client responded by filing his own affidavit to say that the sources of my money are legitimate. He gave that explanation, and we made that application under section 89 of the same law, saying that this decision of the 4th June 2021, which preserved the assets of our client, need to be set aside. Part of our argument was to show in evidence through the affidavit, sworn affidavit from our client, that all the sources of his money are legitimate. And we got all the bank statements that prove the money moving from South Sudan to Kenya. And we provided that a lot of bundles of documents. We submitted them to the court. Myself and my colleagues from Kogwende and Bubi Advocates in Nairobi, Kenya, these were the lawyers that I worked together with to make sure that we successfully filed the application. And indeed we did. So the court accepted our application on the ground of it being expedited, because we provided in evidence through the affidavit that there was an urgency for the court to look into this case quickly. And indeed, the court accepted our argument. One of the arguments is that Dr. Martin has a young family in Kenya. His children are going to school and they need financial support. And you know, when you use other alternatives, such as the Western Union, to transfer money to this bank of Somali called Dapshil, they are very expensive. It costs you more money. But it is safer and better to transfer bank to bank. So we say now this disorganized our client. And so therefore, there is no logical reason as to why this preservation order should stay in place. We ask the court that what we have given here in explanation through affidavit, a sworn affidavit from our client, is something that the court should consider and then address the case as directed by the law. And indeed, the court saw that all that we provided was clear and was to the point.
Justice James Waikanga of the High Court of Kenya made the following ruling. The applicant, Assets Recovery Agency, is satisfied with the explanation provided by the respondent on the source of the funds. The application dated June 2nd, 2021 and July 6th, 2021 is comprised, and the orders dated June 4th, 2021 are rescinded. The respondent is at liberty to operate the account. One of the points that was made was that Minister Lomuro was using his wife, Raja Lado, to transfer money into the corporate bank accounts. Was that the case?
Those were the allegations that were leveled, but his wife was not actually doing that. His wife, she's not a criminal. There is this illusion in Africa when someone accuses you, you are automatically known to be guilty until you prove yourself innocent, which is not the case universally. The case universally is that if you are accused, you are innocent until you're proven guilty. So obviously there was this illusion that Dr. Elia Lomuro's wife was a conduit that was being used to transfer money and to launder money on behalf of Dr. Martin. But the question is, launder money for what? What was the purpose of laundering money? When you launder money, you are actually obviously, under that law, you are involved in criminal activities. So why you're laundering money is that you are hiding a certain thing. Let's say, for example, you're paying for drugs, you're paying for other illegal things, which is not what Dr. Martin's wife, Madam Raja KG, she's not a criminal. She's a mother and a wife.
There's a segment of our population that believe Minister Lomuro is corrupt and was actually participating in money laundering.
That is the thinking. But to be honest, sometimes when I accuse you, Eunice Malas, I accuse you that you're corrupt, I need to bring in evidence. Otherwise, that will qualify as a defamation case against the person that accused you in that way. So obviously, saying that Dr. Martin is a money launderer, is a corrupt person, you have to say that with a clear evidence. Because what happens internationally is that justice need to be served on both sides, you know, on the victim and on the perpetrator. It has to be served on both sides. But when you take one angle and you begin to take that angle as part of your argument without trying to balance the arguments, then it is really not good. Dr. Elia Lomuro is a minister in the government of South Sudan. If he is corrupt, then it is the government of South Sudan, because we have the institutions of the government. We have the anti-corruption, we have the police, we have the prosecution service from the Ministry of Justice, which is the Directorate of Public Prosecution. If there is evidence,
you know, those institutions the institutions you mentioned are considered weak and incapable of carrying out any form of implementing any policies that would bring those who are participating in corruption to book.
But that is, I mean, what do you consider weak? Is it literally the institution that is weak, or is it the people that are in those institutions that are weak? Obviously, the institution is there, and there are capable people there in those institutions. Obviously, we don't underestimate the fact that South Sudan has undergone so many challenges. But despite the fact that we have undergone such challenges, still, we cannot say that the institutions are weak, so we cannot do anything. The institutions are weak, but they have an obligation to do something. If they believe that someone X and Y has violated the law, it is them to bring the case against that person. And it is them to provide in evidence as the law dictates. Now the question is, if the institutions are weak, then who are we now calling to come and prosecute cases in South Sudan? Which angel have we appointed to do that? So this is the issue that we need to consider. We need to be serious. So any country in the world has some challenges. Myself, I came from the diaspora, and the first time when I came into South Sudan, I suffered a lot. I struggled to establish myself because I know we started from nothing to get to somewhere. Other countries, they started from nothing and they went somewhere. So if we begin to say that the institutions are weak, so they cannot do that, then who have we put in their place?
You know, you recently held a press conference in Juba that included the Minister Lomuro. What was the purpose of the press conference?
Well, the purpose of the press conference was that on the 4th of June, Dr. Martin heard of his indictment by Kenyan Asset Recovery Agency through the media. And he had to respond to the media in that manner. First saying that he's aware of what happened and he had nothing to do with it, and that he will consult the legal professionals to see
what is the accusations against him. And he will also try to bring together all his paperwork to clear his name. Now, when the case finished on the 15th of September, 2021, in which the court declared that Dr. Martin, number one, he had given a clear explanation as to the sources of this money, and that he is at liberty to use his account, and that his account, which was frozen, is now unfrozen, and that he is free to transact, and that the case is closed.
Here is part of what was addressed during the press conference.
In the future, the Kenyan anti-money laundering recovery should conform to the country's legal procedures and protocols so as not to victimize people in support of negative policy of external powers with negative political intentions in the region, and especially in South Sudan in this case. I have no doubt that the ARA's action was motivated by the illegal sanctions levied against me on the 16th of December 2019, which baseless sanctions were inspired by the regime change agenda in the Republic of South Sudan.
Procedures are why we're here. Procedures were not followed properly, and that is what we made an application for in Kenya. On considering all the affidavits that were sworn by Dr. Elia Lomuro, the Asset Recovery Agency found that his explanation was satisfactory and was authentic.
Now, during that press conference, the minister went ahead and stated that the events of the charges against him for money laundering have placed his name under disrepute. In relation to that, what have been the negative ramifications that he has experienced as a result of the actions of the Kenya Asset Recovery Agency and the High Court of Kenya?
Yeah, it is true. You know exactly what I told you earlier. You know, in our country here, when people hear that Eunice Malak is accused of something, then they automatically label you as a criminal. So he was labeled as a criminal, and his family was slandered. Also, his wife, Madam Raja KG, they were all considered, and even their circle, their friends, they began to look at them differently. You know that now they are criminals. Even the Kenyans, they have brought a case against them. And so there are people that should not be respected anymore. And also his status in the community, because he's a community leader of his community called Pajulu community in Central Equatoria State. So it was a lot of things going around in his mind, and also people talking ill about him, you know. And also the fact that he's an MP and he's a minister, taken to court without due process and without his immunity being lifted, made many people, including other dignitaries, to look at him that he's a criminal, you know. So, and for him, he had never been to court in the past. He's a British citizen, and he had never been to court in the UK, according to his statement, and he had never been to court anywhere in South Sudan since he returned back from the UK. So he was being seen differently after that, and he was so unhappy that he's now being accused that he has laundered money, criminal, and being seen differently. So that was how he was feeling. He was feeling very, very bad. But after the decision was made and he was cleared, he was very happy.
What does your client believe motivated the Kenya Asset Recovery Agency to take up legal actions against him?
My client believes that Kenyan Asset Recovery Agency is probably misled by some civil societies, because there had been a lot of
civil societies that went forward in Kenya in naming a lot of government officials of South Sudan, including the Chief Justice. There was something that was done the other time on the Kenyan television, KTN, where there were these fake awards that were made and they were given to all the government officials of South Sudan, including the president of South Sudan. And those awards, they were not done in good faith. They were sarcastic awards that were given to tarnish or to mock people. And so my client believes strongly that it was probably the same group. He doesn't have the evidence, but he believes it's the same group that probably tried to target him.
It has been alleged that Minister Lomuro plans on bringing a case against the United States government over the alleged participation in freezing his accounts. What evidence does your client have to prove the fact? And will your client proceed with the case? If he does proceed with the case, will you be representing him as a barrister in the court system?
Okay, for record purposes to our viewers, let me make it clear. My client has nothing to do with the United States. He has no case against the US. Let me be clear with you, especially from the side of the case in Kenya. This is something that I need to make clear.
Some people might consider it because of the fact that the US is among the countries that placed a sanction on your client.
Let me explain. Let me explain. Now, the issue of the Kenyan Asset Recovery Agency, we did our own investigation, where we have not found any evidence linking the US or the US government to the institution of the Kenyan Asset Recovery case against Dr. Elia Lomuro. We have not got that evidence. And we cannot talk on the basis of speculation. Our client is not in that position to speak on the basis of speculative statements. It is not. So the case was purely from the Kenyan Asset Recovery Agency. And there is no evidence that shows that the US government was behind it. There is no evidence that shows that they got involved in it. Nothing. What we do know is that my client is not happy with the sanctions that were unreasonably imposed on him by the US Asset Control Office, AFO. Is not happy with that because he believed that he had done nothing wrong to actually derail the peace process in South Sudan. And in fact, he had been one of the clear and serious advocates of peace to come and prevail in South Sudan. He had not been a general. He was not involved in the field fighting or getting involved in the violence. He had not. He had done nothing. So he believed that on what ground was I actually sanctioned? Yet I had been the four-person negotiating with the IGAD, with the African Union, and also with the region. I had been a senior government official that had been sent always by His Excellency, the President of the Republic, His Excellency Salva Kiir. And he had always...
He was accused of recruiting, of participating in recruiting militias.
You see, what happens is that you have to provide in evidence. This is what the law requires. If you are to accuse someone of something, you have to provide evidence. That's why there are rules of evidence. The rules of evidence require that this evidence that I'm bringing against Eunice Mallard, it is a concrete evidence. It is a legitimate evidence. So what he said is that I have not been involved in any of those things. And he believed that some of those who probably had given statements to the U.S. Asset Recovery, to the U.S. Foreign Asset Control Office. These are people that are probably not knowledgeable on the realities of what happened, or people that don't have a concrete evidence.
On December 16, 2019, the US government brought sanctions against Minister Lomuro. According to the US government, the US Department of Treasury's Office of Foreign Assets Control, OFAS, sanctioned 2 individuals pursuant to Executive Order 13664 for expanding or extending the conflict in South Sudan, including by obstructing the reconciliation process or peace talks. Minister of Cabinet Affairs Martin Elia Lomuro and Minister of Defense and Veteran Affairs Paul Manyang Duok. The US government accused Minister Lomuro of recruiting and organizing local militia to attack opposition forces in South Sudan. The sanctions freeze any US assets held by Minister Lomuro and prohibits US citizens from doing any business with him. Yes, we've been joined on the program by Mr. Anuol Deng Kuoreng, a barrister who took up the case to represent Minister Lomuro against the Kenya Asset Recovery Agency. Thank you for joining me here on the program.
You're highly welcome. And just to make it clear to our viewers, being accused is not the evidence that you're guilty. Being accused is not the evidence that you're guilty. But what is important is the court of law to look at the evidence against you and then determine that evidence is proven beyond reasonable doubt. The case on which Dr. Martin was accused by the Kenyan Asset Recovery Agency was a criminal case. And a criminal case is proven beyond reasonable doubt, not on the balance of probabilities. So without that, you cannot just convict someone. And there are great people of the past that had been accused, but later on you go to court, you defend yourself. And I think this case of Dr. Elia Lomuro should be a wake-up call to many South Sudanese that refuse to go to court and take the law into their own hands. If you are accused of anything, please don't panic. Just go to court. Go and clear yourself, and then you come out clean. It is the court that made the decision. So in the case of Dr. Martin, he did not behave in a wrong way by saying that I'm not going to court, I'm a minister, I'm powerful. He humbled himself and he went to court and he got cleared. So thank you so much. And it is great to chat with you, Eunice. Thank you so much for having me here.
Yes, thank you. Don't forget to subscribe to our YouTube page at Sunrise Media.